welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, July 26, 2023. Today we have sexy cops and sentencing guidelines. Now, usually those two don't go together. I suppose you could sometimes sentence a prisoner under the guidelines when they were arrested by a sexy cop, although not that many cops are all that sexy. Not to besmirch our officers listening today, but there are two particular non-cops, sexy cops that we're going to talk about in one of our cases, and then we're going to talk about a very complicated but very important subject about the federal sentencing guidelines and how administrative law and deference and all that good stuff relates to it. So joining me today to explain these two different but important issues are Jared McClain, attorney at the Institute for Justice, and another attorney I work with here at the Institute for Justice, John Wrench. Welcome to both of you.
Hey, Anthony.
Hey, Anthony. It's great to be on.
Well, we're going to start where I think, everyone's mind is now, which is with sexy cops. And not only were they non-cop sexy cops, but they were in Vegas. Is that correct, John?
They were in Vegas. They were on the Strip, which is a great double entendre. So this case, as Anthony mentioned, is about sexy cops and the First Amendment. So the plaintiff in this case is named Michelle Santopietro. She's an actress. You may have actually seen her in a few different shows, The Sopranos, Sex and the City, and also Law and Order. She is also a street performer. And in 2011, Santopietro flew to Las Vegas to meet her friend. Did she
play a cop on Law and Order, by the way?
Yeah,
I didn't know that.
She has actually played a cop in a couple of different shows, from what I understand.
Amazing.
Yeah, so there's some background. She's an experienced sexy cop. Yeah. So she flew to Las Vegas in 2011 to meet with her friend Leah Patrick, and Santopietro and Patrick planned to meet at the Las Vegas Strip to perform a sexy cop routine. And unfortunately, we've been deprived of a description of what that routine was. I couldn't find anything in the complaint or in the lower court opinion, and the Ninth Circuit but basically avoids it as well. But
we appreciate your due diligence in checking this thing.
I was doing it for all of our listeners, but you can use your imagination. I assume that there were uniforms that were a little bit more revealing than your average cop uniforms. So it sounds like they dressed in sexy cop uniforms and they posed for pictures with people on the Strip. And Santopietro and Patrick are on the Strip one day, and they're approached by three plainclothes police officers. And one of the officers asks, "How much does a picture cost?" And Santopietro says, "It doesn't cost anything. We just ask for tips." And her friend Patrick adds, "We pose for tips. Is that okay?" And then one of the officers says, "Okay," and they pose for a picture with Santopietro and Patrick. And then Patrick says, "Don't forget the tip." And also says, "You said you would tip." At that point, either Santopietro or Patrick ask the officer to delete the picture from their camera if they're unhappy with it, or according to the officers, if there wasn't going to be a tip. So then one of the officers asks Santopietro, "And what are you going to do with my camera if I don't give you a tip?" And Santopietro seems to sense what's going on and says, "I'm not going to do anything with your camera. I'm not going to touch you. What exactly are you trying to get me to say?" Which sounds like she was aware that something was going on.
She knew that from Law and Order.
Probably. Or from the fact that the Las Vegas Metropolitan Police have a history of arresting street performers on the Strip, which I'll tell you more about in a second. But Patrick then tells the officer that although she can't demand a tip, the officer had agreed to pay. And at that point, the officer shows his badge, and Santopietro and Patrick are arrested. So Santopietro sues on various grounds, including that the arrest violated her rights under the First Amendment. the officers move for summary judgment on all of her claims, while Santa Pietro moves for summary judgment just on her First Amendment claim. And the officers' primary argument here is that they had probable cause to believe that Santa Pietro was in violation of a local ordinance that makes it unlawful to operate or conduct a business as a temporary store, professional, promoter, or peddler, solicitor, or canvasser without first having procured a license. So the officers argue, therefore, that Santa Pietro's arrest was valid. And the district court agrees with the officers. It doesn't address any of the First Amendment concerns. The district court says that the officers had probable cause to arrest Santa Pietro for violating the ordinance, even though her friend, Patrick, was the one who reminded the officers to provide a tip. So Santa Pietro appeals, makes it up to the Ninth Circuit in 2017. And the opinion that we're talking about today is an amended opinion. And I'll tell you a little bit more about what exactly was amended, but a lot of this that I'm about to tell you about overlaps with the opinion that was issued in 2017. So in an opinion by Judge Berzon, the court reverses in part. The court begins by recognizing that the relevant question is not whether there was probable cause to believe that Santa Pietro was performing or soliciting without a license. The proper question is whether arresting her violated the First Amendment. And that's because you can't arrest someone solely because they engage in activity protected by the First Amendment. So the Ninth Circuit walks through 3 of Santa Pietro's activities to determine whether each of them consisted entirely of protected speech. So first, the court notes that street performance is clearly protected by the First Amendment. There are plenty of cases saying as much, including a Ninth Circuit decision called Berger versus City of Seattle. Additionally, Las Vegas was previously sued over repeatedly arresting street performers on the Strip. The parties to that case, including the Las Vegas Metro Police Department, had settled the earlier case and entered into an agreement acknowledging that the Las Vegas Strip was a public forum and that street performance is protected under the First Amendment. So arresting Santa Pietro for her street performance would clearly have been unconstitutional. And the court says, of course, officers knew this, that arresting her for street performance would have been unconstitutional. So that could not have been the reason why they arrested her. And then second, the court asks whether Santa Pietro could have been arrested for any of her friend Patrick's statements to the police officers. And here the court assumes, without deciding, that Patrick's insistence on a tip falls outside of the First Amendment. And the court says even if that were true, Santa Pietro's association with Patrick for the purpose of engaging in protected speech is itself protected by the First Amendment. And that's because, for example, police can't punish an entire organization or the participants of a boycott simply because a handful of its members might engage in unlawful activity. The First Amendment prevents that in the same way that it prevents or protects the protected activity in the first place. And then third, the court asks whether any of Santa Pietro's other actions fell outside of the First Amendment. And the only statement that's really in dispute here is whether the officers were asked or told to delete the picture from their phone if they weren't going to provide a tip. But it's not really in dispute. This was actually her friend's statement, not Santa Pietro's. So nothing Santa Pietro did or said would have justified her arrest, and the Ninth Circuit reverses the district court's grant of summary judgment to the police officers. The court then goes on to address whether summary judgment should have been granted for Santa Pietro on her First Amendment claim. The court does not grant judgment for Santa Pietro, but instead remands the case due to some factual disputes. In the opinion filed in 2017, the court indicated that the critical question was whether Santa Pietro was engaging in protected solicitation of tips, or on the other hand, a quid pro quo transaction. But after the 2017 opinion, there was a law review article in the Loyola of Los Angeles Entertainment Law Review criticizing the Ninth Circuit's 2017 opinion. And the article argued that the court drew the incorrect distinction. The question was not whether solicitation of tips versus quid pro quo transaction, because even a quid pro quo transaction would have been protected because it was a consequence of protected speech, Santo Pietro's street performance. So the proper question was actually whether arresting Santo Pietro was a reasonable time, place, and manner restriction. And to determine whether a restriction is a reasonable time, place, manner restriction, courts ask a few questions. One is whether the restriction is justified without reference to the content of the regulated speech. The second question is whether the restriction is narrowly tailored to serve a significant government interest. And third, whether the restriction leaves open ample alternative channels for communication of information. And interestingly, this opinion that was recently amended makes that precise change to its analysis that the law review article was criticizing the earlier opinion for, and remands the district court to consider whether Santo Pietro's arrest was based on a valid time, place, and manner restriction. And all in all, I do not think that the Ninth Circuit opinion bodes well for the officers on remand.
John, do you know if... I get that it seems like the amended opinion was in response to this law review article, but I assume there was a petition for rehearing, something that held up the mandate for all these years while the Ninth Circuit reassessed how the First Amendment works?
That's right. There was a petition for rehearing, which in this amended opinion was actually attached to the denial of the petition for rehearing. And interestingly, the law review article, which seems to be the basis for some of the amended opinion, is not cited, though its reasoning is certainly closely tracked. But that is what held up this for the Ninth Circuit to amend its opinion.
Interesting. Yeah, the thing that stood out to me about this opinion was you're going into this, you're reading about sexy cops. The court uses sexy cops in quotes a couple dozen times. And then next thing you know, we're talking about Clearborn Hardware and the right of the NAACP to engage in boycotts. And I found it makes sense once you get down to it, but just the right to freely associate and how it not only protects the NAACP's right to boycott Jim Crow and racist businesses generally, but it also protects the right of sexy cops to associate with one another. And that's just an important distinction that the Ninth Circuit has sussed out for us.
One question that didn't seem like was addressed, but I was just wondering the whole time is this peddling license that Vegas has and a lot of cities have. Do you get a sense of how hard it is to get? So would it have been that they could have got one if they had just plunked down $50 and then gone and perform? Or is there all these restrictions? There's only one performer per block or something. So they couldn't have gotten it.
Yeah, I'm not actually sure what the burdens of obtaining one of these licenses is. Though it is interesting that it seems like the officers, because of this earlier case that settled, acknowledging that street performance is protected speech, it seems like the officers at this point are just trying to find some way to stop street performers who refuse to get this license, to the extent that they have to go in plain clothes and attempt to bait someone into basically demanding a tip, which might not even be what happened. So even though they haven't obtained this license, the officers are going out of their way to get these people in trouble.
Because the aspect of the case which is challenging that might effectively mean they're challenging the license if they really did, if the jury later finds they really did ask for a quid pro quo for the money, and it does apply to her and not just her partner, then it might shift to, well, how hard is it really to get this license? And I'm sure that the reason for the license is probably revenue. It's not, like a hairdresser's license or something like that. So that could come into play. I was also, like Jared asked, fascinated about the length of time here. So that there was a petition filed. I'm guessing it was for rehearing or in the alternative en banc or something like that. But that was filed in 2017, right, within the short time period that the courts have for those kinds of petitions. And then it literally sat there for 6 years. Like, what was going on? Were there, updates of new case law every now and then, or what happened?
It's unclear what was going on. The petition for rehearing, or like you said, the petition for rehearing or in the alternative rehearing en banc was filed right after the 2017 opinion. So it's unclear from the docket what was going on since then. I don't think that there's been any intervening case law, maybe an intervening law review article, but no intervening case law. And it's crazy that this case was filed in 2011. It's been more than a decade to resolve whether you can arrest someone for doing a street performance in a sexy cop uniform on the Las Vegas Strip. I mean,
the other thing is the relevant facts aren't that complicated compared to, all kinds of other litigation. But I mean, now if they go to a trial, those people's memories are going to be 13, 14 years old. And they're, I said this. No, I mean, what is the jury even supposed to think of? It doesn't sound like there were body cameras. So, anyway, yeah, maybe it'll settle at this point, but there's got to be a story. I know the Ninth Circuit is notoriously long in the tooth with its opinions, but usually that's like a year and a half, 2 years, not 6 years.
Yeah, the clerks that originally drafted this opinion are like up for partner at their firm. But the one other thing I wanted to note about the opinion, we haven't really mentioned qualified immunity, and the court just sort of dismisses the idea that these officers would be entitled to qualified immunity in a footnote by saying that this is an obvious violation of the First Amendment. And when you look at what San Pietro said to the cops and how she knew her rights, it really just comes down to the fact that these sexy cops were better informed on the law than the real cops.
Absolutely. Absolutely. You're right that it even though that you might expect the qualified immunity question to play a bigger role in this, the court dismisses it basically in a footnote to say that this is, because of one of its earlier decisions, recognizing that street performance is protected speech. If the police did arrest Santa Pietro for what it looks like they did, they're not going to be entitled to qualified immunity.
Well, this is quite an interesting strip saga. Thank you, John, for sharing it with us. We'll try and put a link up in the show notes to that law review article and make sure the author gets a little bit of credit here. We'll move on to Jared's case, very different topic, and a topic that I have tried to understand in the past and still don't really. This whole sentencing commission, sentencing guidelines. A lot going on with that. We have administrative law in the mix also today. So, Jared, explain why the 10th Circuit is still going to defer to the Sentencing Commission's interpretation of its own rules. Am I right? Did I frame that right?
That's right. Yeah. So the case, just to start, is United States versus Malloyd. It's out of the 10th Circuit. The opinion is by Judge Phillips, and this case is in a long line of what we call Stinson deference cases. And to understand how we got here, you have to have a sort of baseline understanding of the Sentencing Commission. So we have to start back in 1987 when the Sentencing Commission promulgated the career offender guidelines, which are effectively a federal 3 strikes law. So anyone who has 2 prior convictions for a crime of violence or a controlled substance offense gets a major sentence enhancement put on them when they commit their 3rd offense. And then 2 years after they promulgated this career offender sentencing guideline, they added commentary, which is just the commission's own interpretation of what they think the guidelines mean. And in the commentary, they say, oh, by the way, it's not just crimes of violence and controlled substance offenses, it's also inchoate offenses. So if you've conspired to sell drugs or attempted a robbery, something that is an incomplete offense, they're still going to apply the career offender enhancement to you. And that's a big deal because of how plea bargaining works. As most listeners probably know by now, nearly all cases settle. The government uses these draconian sentences, like the 3 strikes laws, to convince defendants that it's not worth it for them to go to trial. Rather than risk decades in prison over a drug offense, they accept a plea agreement for a lesser offense that very often happens to be things like attempt or conspiracy to commit a crime. And in exchange, the government never actually has to prove that the defendant completed all of the elements of the crime. And so then you have all of these people who have been at some point in their life committed an inchoate offense relating to firearms or drugs, and then they get arrested for a 3rd time, and all of a sudden their sentence doubles. And the Molloy, in this case, the court does a very nice job of laying out exactly what's at stake. If he was originally going to be sentenced, and his plea agreement was for him to be sentenced to 30 months in prison, because that was the low end of the guideline without the career offender enhancement. But because the sentencing commission, the PSR that came out said, no, he has a prior inchoate offense, he needs to be sentenced as a career offender, his sentence automatically jumped to 51 to 60 months in prison, and the court sentenced him at the low end of that guideline to 51 months, but that's still an extra 21 months over what he had thought he was agreeing to when he agreed to the plea agreement. And so the 10th Circuit begins by sort of outlining how we get here, and it's a 45-page opinion on the sentencing guidelines. So it is very thorough and sets it up because after the sentencing guidelines came out, there was a Supreme Court decision called Stinson versus the United States. And the court in that case said that what was at the time called a Seminole Rock deference should apply to the sentencing guidelines. Seminole Rock deference, some people might know by the name Auer deference or now Kaiser deference. And what that means is that courts will defer to an agency's interpretation of its own rules or regulations unless those interpretations are inconsistent with the text or plainly erroneous. And in Stinson, though, it's important to note that the commentary at issue made Stinson's sentence lighter. The question in Stinson's case was whether being a felon in possession of a firearm counted as a crime of violence. The trial court ignored commentary to the guidelines that said that it did not count as a crime of violence, and they sentenced him as a career offender. And the Supreme Court held that the sentencing court should have deferred to the commentary. And because the Supreme Court ruled in favor of the defendant, it never had to address any of the complicated constitutional questions that come up when courts are increasing someone's sentence beyond what the text of the guidelines say. So then, over the next few years, the early 90s, every circuit court of appeals applies Stinson deference to extend people's sentences without regard for whether the guidelines were ambiguous, because back then, deference was pretty reflexive. Courts knew they had this grant of deference from the Supreme Court, and whether it was to an administrative agency or the Sentencing Commission, there's about 24 types of these deferences, and they would just say, the agency says it means this, we're going to rule in favor of the government. And they weren't actually doing any textual analysis themselves. Just if the government says you lose, the court was going to take their word for it. And that's not just like in the normal sense where courts typically give the government the benefit of the doubt on a daily basis. But this was like doctrinally courts saying, our hands are tied. There's nothing we can do. We have to rule for the government because they've interpreted the rule in a way that defeats your claim. And as you can imagine, a bench full of former prosecutors and judges love this stuff and we're happy to go ahead and apply harsher sentences and harsher constructions of regulations and sentencing guidelines. So then you flash forward from the early 90s to 2019, and the Supreme Court takes up a case called Kaiser versus Wilkie. And everyone thinks that the conservatives on the court are primed to get rid of Seminole Rock and Auer deference. They've been complaining about it for years. They've all written separately to say that they think of their own decisions in those cases were bad and they want to reconsider them. But that's not what happens. Instead, Kaiser ends up being more of an admonishment of the lower courts. Justice Kagan writes for the majority, and all 9 justices agree that deference has gotten out of hand, and everybody's been applying deference without any regard for ambiguity. And, that's not the Supreme Court's fault. That's the fault of all these lower courts that just aren't doing the proper analysis. And so the Supreme Court says, if you look what we've actually said in these deference cases, we've always said that there needs to be genuine ambiguity and courts need to start listening to us and doing textual analysis. And we're not going to overrule Auer and Seminole Rock, but we are going to make sure that these guardrails are in place and that the lower courts, they start using all of the tools in their statutory interpretation toolkit before they turn to deference. And immediately after that, the Third Circuit goes en banc on its own initiative in a case called United States versus Nazir. And it says, look, Stinson deference is a form of Auer and Seminole Rock deference. The Supreme Court just told us we can't defer unless a guideline is ambiguous. These career offender guidelines are not genuinely ambiguous, so we're no longer going to defer here. And that has sort of had a cascading effect through the circuits. There were a string of cert petitions for a while, and there was a time in, I believe 2020, where the Supreme Court was holding a dozen cert petitions on this issue and kept rescheduling it. We thought that they were going to grant cert on this issue, and then one day, without any explanation or a separate opinion, they denied cert in every single one of the cases. And my best guess for why that happened is that under President Trump, he let the Sentencing Commission lose its quorum. So there were not people on the Sentencing Commission to actually correct any of the problems that the lower courts had identified with the guidelines. And the Sentencing Commission, the people who were still there waving their hands but powerless to do anything, were sort of signaling that they were going to fix all of these problems so the court didn't have to get involved. And the SG was saying, look, the Sentencing Commission can fix this itself. You don't have to take cert in this case. And so the lower courts keep up with their course correction, and most of them who are revisiting the issue are coming out in favor of the defendant and saying we're no longer going to defer here unless there's a genuine ambiguity. The 11th Circuit came along recently en banc. The 5th Circuit just went en banc. And now the 10th Circuit is looking at this issue in Malloyd, and they say we know that there's a split and we are not going to join all of these circuits who are now saying that a sentencing guideline needs to be genuinely ambiguous before you defer to the interpretation of the Sentencing Commission.
And sorry to interrupt, Jared, has the Sentencing Commission now, it's up to strength? Has it moved in this direction at all? Do we know?
Yeah. And so that is what, there are many bad things with this opinion that I'll get into, but the worst of them might be that the Sentencing Commission has now moved this commentary into the text of the guideline, and it's set to take effect in November. And so that's going to kill this issue, and it's not going, it will just give the Supreme Court another reason to put off. It happens to other guidelines, but the career offender one is the one that happens most prevalently in. So I'm sure that will allow the split to fester for a little while. And it has a big effect on people's lives. I represented a guy named Marcus Broadway out of Arkansas, and the point we were making was the Sixth Circuit had gotten rid of the reflexive Stinson deference, and the Eighth Circuit did not. And if he lived on the other side of the Arkansas-Tennessee border, he would have been in jail for half as long. And the sentencing guidelines are in place to promote uniformity of sentencing, and having this split accomplishes the exact opposite of that. And so going back to the Tenth Circuit and Malloyd's case, the panel reaches sort of one holding, but they have three main points about what they're going to do with Stinson deference going forward. And one of them is for the unanimous panel, and then two of them only two judges joined. And the breakdown is interesting, and it has been interesting in all of these cases because there's agency deference involved, which at this point in time is something that the liberal judges tend to favor more than the conservative ones, even though a couple decades ago it was the opposite. And but then you have criminal sentencing, which liberals tend to be more lenient on. And so you get sort of this mismatch of priors that the judges have. And when the Third Circuit went en banc in Nazir, there were judges in the majority appointed by five different presidents.
Wow.
And the split was just not ideological at all. Judges were all over the place. And then you get this decision from the 10th Circuit where the Trump judge only joins the main point of the opinion, which is that the Supreme Court in Kaiser did not expressly overrule Stinson, so the 10th Circuit believes that it is still bound to apply Stinson regardless of whether there's ambiguity. So what they're saying is that until the Supreme Court takes up all 20 different kinds of deference individually and overrules them or does a course correction like they did in Kaiser individually for each type of deference, they're not going to apply that rule out more broadly. They're not going to draw any general principles from that case. They're just going to make the court take up the issue one at a time. So for the next 30 years, we're going to be here still applying deference in cases when the court shouldn't. And that is the only portion of the opinion that all three judges sign on to. And a lot of the work in this portion of the opinion, I think, is done by this idea that the court keeps repeating by saying that Kaiser announced a new rule, rather than what the Supreme Court said in Kaiser, which is that it was just reinforcing the guardrails that had always been in place for deference and had existed since Seminole Rock. And that makes a difference because if these guardrails were in place at Seminole Rock, then that is what the court was applying in Stinson, and they should apply in the Stinson context. And ironically, it's sort of a legal realist view from the panel here of what Kaiser did, because if you can think back to 2019, all of the fights that the Supreme Court was having were about stare decisis and whether they were going to upset precedent because the liberals on the court were scared about the conservatives overturning Roe, and they went out of their way in every case to make sure to say that they were respecting precedent, and this was not a new rule, and it was just the lower courts that had been wrong the whole time. And the panel in Malloyd says, we were taking our cues from you this whole time. You expressly said we didn't need deference or we didn't need ambiguity to defer in some of these cases, and we're not going to pretend that Kaiser wasn't announcing a new rule when we all know that it was.
Yeah, I think most people who read Kaiser say it's new, and there's something new here.
And that distinction causes them to say that the rule from Kaiser can't extend to other cases, and so they're still bound to apply Stinson. And that's where Judge E drops off of the opinion, and it's left with just the two democratically appointed judges who go on to say two more things. And the first is that the rationale of Kaiser did not reach the Sentencing Commission because Kaiser was talking about deference to executive agencies, and the Sentencing Commission is nominally in the judicial branch. So the reasoning doesn't make sense, even though you could say the same thing about Seminole Rock, which was the original form of that deference. And then they say that the concerns about deference don't apply in the Stinson context. And that's where I think things really go off the rails. So, like, one thing about this opinion that gets me mad in particular is that we're talking this whole time about deference, and this is a case about Stinson deference and how courts should apply, whether you need genuine ambiguity, when you should defer to an agency's interpretation of its own regulations. But it's not like this isn't a case about genuine ambiguity. There's no ambiguity here. The sentencing guideline very clearly lists all of the offenses that apply, and it does not include inchoate offenses. And for that reason, the D.C. Circuit, the most deference-friendly court in the country, quit giving Stinson deference to the career offender guideline back in 2018 in a case called United States v. Winstead before the Supreme Court even decided Kaiser. What they said was, the guideline says one thing, you can't just pass commentary that says something completely different. And so to say that this is a deference case is just allowing the United States Sentencing Commission to change what the guidelines mean without actually having to pass new guidelines. And that's important for a second reason that the panel here skips over. The panel says that there are no separation of powers concerns here because we're not talking about executive agencies. But the power to craft sentences is a legislative power, and it's then the job of the judges to decide how that sentence applies in a case. And by placing the Sentencing Commission in the judicial branch, the Supreme Court has said in a case called Mastretta that is only allowed because of two important protections on the sentencing guidelines. The first is that they have to be promulgated through notice and comment rulemaking. And the second is that they have to go before Congress and be expressly approved by the legislature. And neither of those two things happens with the commentary to the guidelines. So the separation of powers concerns that would exist if not for those two protections of the Sentencing Commission do exist for the commentary, and the panel sort of glosses over that. And the other thing, they say that there's no due process concerns at all. And they completely gloss over the idea of lenity and the due process concerns that are inherent when courts increase someone's sentence beyond what the guidelines say. Now, lenity is a rule that some listeners may be familiar with. It's been around since the 1400s, back when they used to do law and what they called a yearbook. I guess everyone back then, they'd get their picture and their senior quote in the yearbook, and there was a guy named Judge William Paston, and his senior quote was, "Penalties ought not to be increased by interpretation." And that has stuck with us for 500 years. And as recently as this term, lenity was in the news because Justice Jackson joined Justice Gorsuch in a case called Bittner versus United States about the Bank Secrecy Act, and reiterated that the courts have to strictly construe penalties under the rule of lenity. And there's three main constitutional reasons for this. It's a due process concern, like I said. It's separation of powers based on who gets to impose the sentence. And there's supposed to be a constitutional preference for liberty. Basically, the tie should go to the defendant in these cases. And the due process concern is that for a fair warning about what a sentence will be to be clear, the legislature has to speak clearly. Like, they have to say, exactly what a punishment is going to be, and they did that here in the sentencing guidelines, and they can't just use commentary to get around that. And the panel in Malloy just ignores that entirely. I could keep going for a little while on this, though. So if you guys want to cut in and let me.
I mean, something that you just mentioned about lenity, when you were discussing Stinson, I was thinking of, you could see how Stinson, even if it wasn't the articulated rationale for that decision, it's consistent with principles of lenity, right? And it shows why it's important to pick the right rationale for that decision, because by basing it on deference, what in that case ended up being more protective for the defendant, you actually open the door for what is, if you're one of those judges, you might have thought the likely outcome of allowing deference here is actually not going to be for defendants most of the time. It's not going to be good for defendants. But you might be able to see Stinson as like at least being animated by a principle of lenity. But it makes sense that, if there is real ambiguity, like you said, the tie should go to the defendant. It doesn't make any sense at all that in when there's ambiguity in a case involving a criminal defendant, that it goes to enforcement against the defendant. That's crazy.
Yeah, and that's a point that I've tried to get across in my briefing on these cases. Is just like in Kaiser, they said you have to empty the interpretive toolkit, and one of the tools in that toolkit is lenity. And when there are criminal penalties on the line, you can't give the tie to the government. You have to go in favor of the more lenient sentence.
Yeah, it seems like a pretty massive contradiction where you have on one side this our deference, and then on the other side you have the rule of lenity, and they're exactly against each other. And so how can our deference beat lenity there? Other than that, in our day and age, the rule of lenity has been so circumscribed that it hardly ever comes up, and so you could argue that it's just not a thing when it comes to this. One basic point I have that it may have addressed early on, Jared, is the Sentencing Commission. Like, how does it? Who appoints it? How exactly is it composed? I mean, it seems like this really weird kind of extra Article 1, Article 2, Article 3 type of body that is a little bit judicial, a little bit legislative, a little bit executive.
Yeah, it is definitely so. They're appointed by the president, I believe, because that is, I think, why there was not a quorum under Trump. And my understanding, which I have not looked into this in 4 years now, but I think that they are a variety of judges, and they sort of get together and try to decide what the good sentences would be. Justice Jackson had been on the Sentencing Commission, and Breyer spent a lot of time with the Sentencing Commission, but there are also lower court judges on it. But it's the panel in Malloy makes a big deal about how, like, these are judges, they're doing judicial things, but the Sentencing Commission's role is not actually judicial. They're not doing any judges. They happen to, like, their day job might be to be a judge, but when they're promulgating guidelines through notice and comment rulemaking that goes through the legislature, that's not a judicial act.
And it's the same people that do the commentary? Is that right?
That's right. And the panel makes a point in the opinion that, like, so funny enough, there is commentary to the guidelines that says that the commentary is binding. So even though Congress has not decided it, the commentary to the guidelines tells judges that they should listen really strongly to the guideline or to the commentary. But the commentary doesn't have to go through notice and comment, and it doesn't have to go through Congress. But what the commission says is that they endeavor to do their best to show it to Congress. And, like, that's just a different standard. And when we're talking about like formal rules and the way things are supposed to work within a constitutional system, for the majority or for the panel in Malloy to look at that and say, close enough, but then say, okay, we need to take that commentary as fully binding and sentence this guy to an extra 21 months in prison, it just is once again giving more leniency to the government when they don't follow the rules than the courts do to criminal defendants. And like the panel in Malloy makes this point about how, the sentencing guidelines, they're not actually binding anymore, but it's extremely difficult to have a downward departure from the guidelines. And besides that, under like even granting the panel that the guidelines are not strictly binding on the courts anymore, under the 10th Circuit's interpretation of Stinson deference, the commentary is. So the perverse result of this decision is that the commentary of the guidelines is now more binding than the guidelines themselves.
That's crazy.
So, yeah.
And going forward, it sounds like this particular case and this particular issue probably isn't going up because of this change you said in the law coming in December. But is there other percolations of this deference issue that's going to eventually have to make its way now that with this split?
Yeah, so it'll be interesting to see what happens, because I think in our cert petition for this issue years ago, I believe we identified like 4 different guidelines that this was happening to, and like it could happen to any. My sense is that if the Sentencing Commission has taken it upon itself to correct this one issue and move the commentary into the guideline, they will just continue to do that to keep the issue from getting to the court. And even if there's cases like this where it's still happening, and into the 10th Circuit and the First Circuit, which also refused to reconsider its precedent, there's not going to be a strong of a case for the defendants to make an cert petition about why this issue is of national importance for the Supreme Court to take it, because it'll happen so infrequently. So at least as the Sentencing Commission seems to be currently constructed, it seems as if it's going to be a long time, if at all, before Stinson deference gets to the court. And, there's a chance they consider Chevron deference, which in Kaiser, Chief Justice Roberts noted is a completely different beast, and he doesn't think that the logic of that whatever the court is saying about Auer and Kaiser and Seminole Rock, it actually applies to Chevron. So then you're back into the situation of, even if they do say something about Chevron now, that probably doesn't reach Stinson deference, particularly in circuits like the 10th, where they're going to make the court take up all 19 kinds of deference and say it one at a time.
Yeah, that's something I wanted to comment on, because it just seems like when you have these doctrines that result in, many more offspring, when there's a criticism of the original doctrine, it seems unlikely that there's any way to fix all of the other offshoots unless you do them one by one, because the nature of litigation is that you need a case, right, to challenge the particular application of a particular form of deference. The courts are probably only going to weigh in on that particular application of deference, and it seems like unlikely that especially lower court judges are going to weigh in on other forms of deference, in part because they want to be limited to the case in front of them. But on the other hand, there's incentives to have these deference doctrines as a judge. Statutory interpretation is hard,
makes it easier,
and ambiguity is difficult to deal with. So it seems likely that it's going to be, like Jared said earlier, decades of cleanup of these deference doctrines.
And like when you look at, like, the justices would have to think long and hard about how what they're saying in in our deference case might affect, like you look at the affirmative action case where they dropped that footnote and saying like, we're not going to consider how this applies to service academies. It's the same type of thing. They're like, this is the case before us. We're only thinking about this one thing. And we don't want you to take our words necessarily to apply to other circumstances that aren't presented before us. And like, there could be good reasons for doing that. But if the lower courts are going to refuse to learn any lessons from those decisions and just say that they're strictly bound until the Supreme Court gives them permission to do otherwise, we're going to be in this for the long haul. And yeah, it's unfortunate because I think there's 75,000 people sentenced under the guidelines a year, even just waiting till November for that. That's however many thousands of more people are having their sentence double due to deference rather than what the actual guidelines say.
Yeah. And well, we will look forward to any more percolations on this issue for Short Circuit. The Chevron deference you guys are talking about, just to enlighten a few non-lawyer listeners who are still with us, that is about deferring to the executive's interpretation of what laws that Congress has passed, and then, or an agency. And then what we're talking about here is the agency itself interpretation of its own rules, which has always struck me as even further a bridge too far of deference. And then there's many percolations of that, as we've learned, and many precedents of that often contradict each other. So we'll look forward to those in future shows. Thank you both for explaining some complicated issues about some complicated topics today, including sexy cops and sentencing guidelines. And we'll look forward to you joining us next week, dear listeners. But in the meantime, I hope that all of you get engaged.